I'm Ed Hernan. I'm head of Blue Stack Productions, the publisher of Irish Environment, an online magazine covering environmental matters on the island of Ireland. I'm very pleased today to be here in Dublin with Andrew Jackson, who's Assistant Professor of Law at the University College Dublin. Andrew, it's good to see you again.
Good to see you.
Now, Andrew, your background is you have a BA at Oxford University in Law. Andrew has a Master's in Law from Cambridge University. He has a Master's in Science in Biodiversity and Conservation from Trinity College Dublin, and he has a PhD in European Union Environmental Policy and Law. So he's been busy for the last couple of years. And what do you specialize in anything at UCD, University College Dublin?
I teach environmental law, planning law, climate change law and policy, and I run a sort of legal placement internship module over the summer for undergraduate students. So I teach in the general field of environmental and land use law to undergraduates and graduates. The UK Government's Department for Environment, Food and Rural Affairs, DEFRA, was advertising at that time for lawyers. This would have been during the Tony Blair government, when the civil service was a fair bit larger than it is now. So I applied to DEFRA.
And how many years were you there?
I was for about 2.5 years with DEFRA, from 2005 to towards the end of 2007 when I moved to Ireland.
And then you were doing some work with the Friends of the Irish Environment. Was that legal work or other kinds of work?
All sorts, really, policy work and legal work. So when I moved over in 2007, I went back to university and did the Masters and the MSc you mentioned in Biodiversity and Conservation. And at the same time, and that led on then to a PhD. Over that period, I was working on a voluntary basis with Friends of the Irish Environment.
Okay.
With my legal background, I was, I guess, giving a lot of legal input to issues that they were working on.
Okay.
And of the environmental NGOs in Ireland, Friends of the Irish Environment would be one of the most, legally focused. It has one of its specific aims is to see EU environmental law properly implemented and enforced.
So it's more active in litigation-wise than many of the other ENGOs.
It would be, yeah, for sure.
And was there particular areas that were you working on the bogs issues with?
That was one of the things that we worked on quite a lot in that period. But we worked on all sorts of issues. Some would be of our own initiative, so issues that we felt were important, like conservation of the hen harrier would be one of the big issues I remember working on. But also, Friends of the Irish Environment would be contacted a lot by members of the public with issues, people who were looking for help with an issue that had arisen. I did a lot of work in 2007 and 2008 on a dispute relating to Sligo Airport, which had plans to extend its runway out into the bay, and ultimately that plan was defeated, and it was defeated by a combination of, I think, the law and financial crisis, which kind of put paid to the plans, and the plan hasn't come back as far as I'm aware. But it was all sorts of work, really. But given my interests, a lot of nature conservation work. Yeah.
And then you went to Antoshka. And what was your position at Antoshka?
So I was initially hired as Natural Environment Officer. So sort of heading up the office, working on natural environment issues. So the office there is sort of divided between natural environment and environment built heritage. And then a few months in, I sort of also became in-house solicitor. I was entitled to practice here and got my practicing cert, and then became in-house solicitor for Antoshka. So then was involved in providing legal advice, but also litigation for Antoshka.
Now, there's a couple of cases that we've talked about before that I thought we might share with the audience. When you were with Antoshka, the first is the Hinkley nuclear power facility, which is still currently the subject of a great deal of discussion. And what was that case about on behalf of Antoshka?
So essentially, for those who don't know, Hinkley Point nuclear power station is the first new nuclear power station permitted in the UK in decades, and it is due to be on the west coast of England. So it is closer to Ireland than it is to many parts of the UK. And as part of the permitting process in the UK, there was an extensive consultation exercise with the public, but there was no similar consultation exercise with the public in Ireland. And there's an international legal instrument called the Espoo Convention, which relates to the requirement for transboundary consultation for large projects that require environmental impact assessment, and that filters down into EU law and then into the law of England and Wales. And so the case was essentially that the UK government ought to have consulted the public in Ireland before they gave permission for the new nuclear power station to go ahead. And it was argued before the High Court. In this case, I think the argument was really very strong under international law and EU law. Nevertheless, we lost before the High Court, but had the opportunity then, or were granted permission to appeal to the Court of Appeal. And during the course of that hearing, very much had the impression that we were, even if not going to win outright, we were going to be successful in having the case referred to the European Court in Luxembourg. And I think the outcome then would have been that we would, had a reference been made, I'd be pretty confident that we would have won on the law. And then the judgment came out and no reference and lose on all grounds, and essentially. And it was very, I have to say, it's the most disappointing outcome in a legal case that I've been involved with, in the sense that really felt that we were going to win and ought to win. And in fact, the legal argument has since been vindicated, because in parallel to the court proceedings that Antashka took in England, Friends of the Irish Environment made a complaint or communication to the Implementation Committee of the Espoo Convention, which is, the international law enforcement body essentially, raising the same legal argument, which was essentially, the argument is, if the project is likely to have significant effects on another state, then there needs to be consultation with the public in that other state. And the question is, what does likely to have a significant effect mean? Is that more likely than not, or is the trigger set lower than that? And ultimately the Implementation Committee of Espoo, pursuant to Friends of the Irish Environment's communication, said the trigger is as low as we were arguing that it is in the case before the High Court of Appeal in England. But unfortunately that decision of the Implementation Committee came too late. By the time that decision had been given, we had been refused leave to appeal to the Supreme Court. So we had reached legally the end of the road. And it was very disappointing, because it was it's a very big missed opportunity for EU environmental law, setting to one side the substantive issue, and focusing on the case as an sort of environmental democracy case rather than a case about nuclear power.
Now, the other case you worked on was the County Offaly power plant and the bog issue. Tell us about that.
So yes, that was Edenderry Peat-Fired power station, which, as you know, is one of 3 peat-fired power stations in Ireland generating electricity. Edenderry coal-fires peat biomass. And the argument there was that so Edenderry had a time-limited planning permission, which was due to expire, because at the time it got permission originally, climate concerns were around then too, and so the feeling was, give it permission, but make it time-limited and then reconsider at the end of that period. So Antashka became involved when this re-permitting process was coming up. So Board Namona was applying for permission to continue operating, essentially, for fresh permission to continue operating. And they received that permission, and they had produced an environmental impact statement for the purpose of that application, and there had been an environmental impact assessment, but the assessment had considered, if you will, if you imagine this, my glass here is the power station, and you draw a red line around it, and we say this is the project power station, and we'll assess the impacts of that. But the EIA directive says that all direct and indirect effects of an EIA project have to be assessed. And Antashka argued that the extraction of the peat from bogs nearby to supply the power station was either a direct or indirect effect of the power station itself, and that therefore the peat extraction ought to be subject to environmental impact assessment. And that would be a new thing, because there had not been environmental impact assessment of peat extraction from those sites, from Bord na Móna sites in the past. So it was an important issue of principle, as well as an important issue on the facts, trying to bring industrial scale peat extraction within the regulatory net, requiring assessment. And so that case was before the High Court in Ireland last summer, and Antashka were successful with their case, and so obtained an order to quash the permission. In the meantime, Bord na Móna had prepared for that eventuality by putting in a fresh planning application which remedied the defect that had been identified in the case. So they had produced an environmental impact statement which considered the environmental effects and impacts of peat extraction. So that fresh application was working its way through the process, and it's still working its way through the process. So the court put a stay on the effect of the order that Antashka obtained, pending the decision from the Planning Appeals Board on Bord Pleanála. And that's where we are now.
In general, Andrew, what's the kind of nature of the legal practice and availability of legal resources in Ireland these days for citizens or environmental NGOs to get access to the courts? Does the Art House Convention advance that possibility?
Certainly, it has advanced the possibility, and the situation is quite complex in the sense that it's tied up with the rules of legal costs. So the apportionment of legal costs.
If you could kind of just give us the general rule, and then what's the kind of general exception under our house?
So the general rule of litigation would be, in action for judicial review, say the loser pays. Right. So you run a risk under the loser pays system of bankruptcy, certainly, because if you take an action for judicial review and lose, then you would likely be facing a bill of 6 figures. And so that is enough to put off most individual litigants, most organisations. If you think of an environmental NGO which has to, within its structure, say, get approval of a board of directors to take a legal case, that's a very difficult decision for a board of directors to take, looking at its duties and so on, to say, yes, we're going to expose the organisation to this risk in this case. But pursuant to the Aarhus Convention, Ireland has changed its cost rules in certain limited categories of cases. So where those special rules apply, as a first principle, each side bears its own costs. So you go into the case knowing that if you lose and the rules apply, you won't have to pay the other side's costs. And then the second limb of the rules is the court has discretion to award a winning applicant its costs, or a portion of its costs. So essentially you can go in knowing you're not exposed, provided and you can lose that protection if your conduct of the case is frivolous or vexatious. There are various ways that it could be lost. But if you go in and conduct the case properly, and you're within the rules, you can think, okay, I'm not going to be exposed to the other side's costs, and there's a good chance if we win that it'll be possible to recover costs or a portion of costs on a market basis.
Basically the lawyer's fees.
Exactly, and what that means is that opens up the possibility for lawyers, public interest minded lawyers, being willing to take cases on a no-win, no-fee basis. Because if they are comfortable that the case is a strong one and that they'll be able to recover, even if not 100% of their costs, a reasonable percentage of their costs, then there's a pool of people then who'll be willing to take cases for individuals and NGOs which are poorly resourced on a no-win, no-fee basis. So the Edenderry case that you mentioned was an environmental impact assessment directive case, meaning that it fell within the special costs rules.
So you could afford to take that case because of the
cost rule that applied in the Hinkley case. The UK rules apply more generally, so they're not limited to say EIA directive and a few other areas. They apply more generally, but what they do is they cap costs. They apply a reciprocal cap. So they say if you're an individual litigant and you lose at first instance, your exposure is capped at 5,000 sterling. If you're an organisation, it's capped at 10,000 at first instance. So for the High Court, say judicial review, but there's a reciprocal cap. So if you win, your recovery is capped at 35,000. And what that means is that, say in a case like Hinkley, we would have had, a law firm, and we would have had senior counsel from Matrix, and we'd had junior counsel, and they, had we been successful before the High Court, would have been limited to recovering 35,000 and would have been sharing that out amongst themselves, and that would not, had we been charged on a market basis, for hours spent, there would have been many more hours than 35,000 sterling.
Multiples of that,
Absolutely. So it's not a market recovery basis in the UK, and it's what that means, I think, is that you then restrict the pool of people willing to take the cases.
Has the number of lawyers in Ireland who kind of not specialize but do some portion of their work in environmental law changed over the last 10 years or so? Are there more and more lawyers accessible for litigants in environmental cases? Or is it fairly limited?
It's fairly limited, I would say. I think it's a
couple dozen or less than that?
Less than that, I would say. Although it's hard to know, because you tend to get to know certain people who work in the area, who go to conferences and speak at things and make it known that that's an area that they're interested in. But certainly at the junior end of the bar, you'd imagine that there would be quite a lot of people who would be, willing, interested, delighted to cut their teeth on different types of cases, who you might not think to approach because you just don't know that they're interested. So I think if more people were aware of the possibilities provided by the Irish cost rules, even within the bar law profession, it might generate more people interested.
Are you limited in the kind of consultation you can get from experts on environmental cases?
Yes, getting expert advice is always or expert reports is always an issue. And it tends to arise because of the legal system here, because of the way judicial review works. The utility of expert reports and so on tends to be earlier in the process, so at the administrative decision-making stages, so before, say, Board Planala, Planning Appeals Board, where there's a substantive hearing and decision on the facts, where you can get an expert to give a view. And the problem there is, at that administrative review stage, Board Planala typically will not award costs. So they may hold an oral hearing, say, and it may last several weeks. And so an NGO or an individual may take time off work and attend an oral hearing and present arguments and get an expert, maybe get lawyers to argue for them, but there isn't that possibility of recovering costs, even if successful. So that's certainly a difficulty, is finding experts who are willing to give expert advice in a way that's not prohibitively expensive. By the time you get to court, I don't know quite how it works in the States, but by the time, say, you get to an action for judicial review, the issues are narrowed down to, has the decision been taken lawfully, and the the court typically won't delve into the facts in that way. They won't rehash the decision of the administrative decision makers.
Yes.
They'll say we're not experts in this. We can't choose between these experts, and that's the function of someone lower down the chain.
Now let me switch that a little bit and ask you about the authority, the EPA, Irish Environmental Protection Agency. Does it have power to take actions against polluters or in courts, and does it do that very often?
It has become more active in doing that. I think my perception would be it's become more active in recent years. It took an important case within the past few years against an unpermitted and large peat extraction company. Unpermitted in the sense that it didn't have one of these integrated pollution prevention and control licenses I mentioned, which are required where you are operating a peat extraction site of greater than 50 hectares. So quite large sites, and there are quite a few companies in that sector that don't hold these licenses. Bord na Móna, in fact, the semi-state peat company would be the only company that does hold an IPPC license for that activity. So the EPA effectively took a test case against one of these large peat extractors and said, look, you ought to have a license. You have to have one of these licenses. And the EPA was successful before the court at first instance and got a good decision handed down. But the peat extractor has appealed to the Court of Appeal, and I think the case is still pending. In the meantime, the central government is looking at this whole area of bringing industrial scale peat extraction within the regulatory net. So in fact, by the time that case runs its course, the goalposts may have shifted and the legislation will have changed.
So at least there's the authority for EPA to act. Whether it has the resources to do that's quite another matter.
And it does bring prosecutions in various areas, but it would have a small legal team. And as you know from your own work, one case swallows up so much resource that it's not possible to take on everything at the same time. But it's definitely a positive development that the EPA is going out
being
and
proactive,
taking on some polluters, some unlicensed operators, and so on. It would be great if they would do more, or if that unit could build up to be larger and they could take more cases. But it's good to see.
Andrew, thanks for talking with us today.
Thank you very much.